this sounds like you, stick around. This video's for you. You're launching a startup and someone offers to invest, but now you're wondering whether to issue shares or use a safe note. You've heard that convertible notes are supposed to be simpler, but you're not sure what the tax or control consequences are. You've already transferred shares informally, and now you're facing a legal or tax mess. If you're a founder raising capital or issuing equity in a startup, this video will help clear things up. I'm Damin Murdock, principal lawyer at Leo Lawyers. You may already know me, or this is the first time you have visited our website or video library. Although this looks like me and sounds like me, this is my AI avatar presenting this video using the script that I have written and approved. At Leo Lawyers, we assist clients in completing their capital raise, whether it is by way of a safe convertible note, issuance of shares, or by a debt facility. We're here to assist you in fueling your growth. Let's start by explaining what safe notes are and when they should be used. A simple agreement for future equity, commonly known as a safe note, is a legal tool often used by startups to raise funds from early supporters like friends and family. Unlike a convertible note, a safe doesn't allow the investor to later demand repayment of their money plus interest. Instead, the investor puts money into the company with the understanding that down the line, typically at a major funding event, that investment will convert into shares. And when it does, it usually converts at a 20% discount to the valuation that future investors come in at. So why not just issue shares immediately? Because at the early stage, most founders don't know what their company is actually worth. The business likely hasn't started trading or developed a clear market yet. The safe helps avoid either undervaluing or overvaluing the company too early. This protects both the founders and the investor. The founder avoids giving away too much equity too soon, and the investor gets a discount when the company's value becomes clearer. When does the safe convert into shares? Generally, the safe investment sits in the company until either a maturity event, usually around 24 months, or a qualifying equity round, which is often a capital raise of around $1 million or more. For example, let's say your parents invest $100,000 into your startup and sign a safe. The maturity date is set at 24 months. After 12 months, your startup raises $1.5 million at a $5 million valuation. Just before that raise is completed, your parents' safe converts into shares at a $4 million valuation, giving them the promised 20% discount. Their $100,000 investment now becomes equity, and they sign a shareholders agreement and are issued shares. Then, the company brings in the $1.5 million from the new investors, who also sign subscription agreements in either the shareholders agreement or a deed of accession which binds them to the same terms. Why use a safe? For startups, the big benefit is simplicity. There's no need to value the company early on. It also delays giving out shareholder rights. Until the safe converts, the investor isn't a shareholder, so they don't have voting rights or access to dividends. For investors, a safe offers a way to support an early-stage company without overpaying. They avoid investing at an inflated valuation and get the benefit of a discount when shares are eventually issued. But there are downsides. Investors don't become shareholders until the safe converts. That means they're not protected by the Corporations Act, and they usually don't have the right to access company records or financials. That said, these gaps can often be addressed by including information rights, which allow access to monthly, quarterly, or annual reports, and a most favored nation clause, which ensures their shares will have the same rights and privileges as those issued in the future raise. What about convertible notes and how do they work? A convertible note is a debt instrument. That means once someone invests in your startup using a convertible note, it shows up on your books as a loan, not equity. Why? Because under a standard convertible note, the investor has the option to either convert their investment into shares or be repaid their original investment plus interest, either by the maturity date or at the time of the next equity financing round. When they choose to convert, the shares are typically issued at a 20% discount to what future investors pay. Sometimes there's a valuation cap instead. For example, a clause that says the investment converts at either the 20% discount or no more than a set cap, like $4 million, whichever is lower. Let's break it down. Say your friend invests $100,000 into your startup using a convertible note. The note, one, has a 24-month maturity date. 2 says that if a capital raise happens during those 24 months, it triggers the investor's right to convert to shares. 3 includes a 10% coupon, which is essentially interest on the investment. And 4 sets a valuation cap at $4 million. Now, after 12 months, you find new investors willing to put in $1.5 million at a $5 million valuation. Your friend decides to convert the convertible note into shares. At this point, your friend's investment converts to shares based on the original $100,000 plus $10,000 in interest at a $4 million valuation, thanks to the valuation cap and 20% discount. After that, the company brings in the new $1.5 million from investors at the $5 million valuation. So, what's the catch? While convertible notes offer flexibility, they can be risky for startups. Here's why. The investor might choose not to convert and instead ask for their money back with interest. Let's say you tell the investor you're raising $1.5 million at a $5 million valuation, but they believe your startup is only worth $2 million. They may decide it's not worth converting and demand repayment instead. The problem? By then, you've probably already spent the $100,000 and might not have the funds to pay it back. That's considered an act of insolvency. Even worse, future investors usually don't want their money used to repay debt. They want their investment going towards growth, not cleaning up the company's past obligations. So, if you can't find the cash to repay the investor, your startup could be in serious trouble. Why do investors like convertible notes? Because they get the upside of equity, but with downside protection. If things go well, they convert into shares at a discount. If things don't go well, they can ask for their money back. But it's not risk-free for them either. If the company can't repay, which is common in early-stage startups, the investor is stuck. Their options are limited to letting the interest keep accruing or trying to wind up or liquidate the company. And if they choose to let the debt sit, that outstanding liability can scare off future investors, putting both the startup and the investor in a precarious position. Finally, let's let's talk about issuing shares in a startup and how it works. Issuing shares usually happens when a startup feels confident placing a valuation on the business. That valuation might be based on projected revenue, signed contracts, or historical revenue performance. Once a valuation is agreed, the typical process starts with a term sheet, a high-level document that outlines the key commercial terms of the deal, including what will go into the shareholders' agreement, the company constitution, and the subscription agreement. Once everyone agrees to the broad terms in the term sheet, the parties move on to draft and negotiate the transaction documents, the full legal agreements. What happens when terms are finalized? The investor signs the subscription agreement, confirming their commitment to invest in return for shares in the company. In this document, the startup will usually provide certain warranties. For example, confirming there's no outstanding debt, there's no ongoing litigation, the company owns its intellectual property, and all taxes have been paid. Once the subscription agreement is signed, the investor transfers the funds. They also sign the shareholders' agreement, or a deed of accession, which binds them to an existing shareholders' agreement. The company updates its share registry, issues a share certificate, and notifies a SIC of the change in shareholding. What are the benefits and the downsides? For the startup, the main benefit is certainty. The investment is made in return for shares. No loans, no convertible instruments, and no deferred conversion events. The downside, the new investor is now a shareholder. That usually means they get voting rights, they're entitled to dividends if declared, and depending on the terms, they may even have the right to appoint a director. For the investor, the benefit is stronger legal protection. They're now covered under the Corporations Act, including Section 232 and 233, which prevent oppressive or unfair conduct towards minority shareholders, directors' duties to act in good faith and in the best interests of the company, and if they hold at least 5% of shares, the right to inspect the company's books and records, as long as it's a reasonable request for a proper purpose. A quick warning, avoid transferring founder shares to investors. Founders should not transfer their personal shares to investors, except in very limited, exceptional cases. Here's why. Let's say the founder owns 100 shares. An investor comes in, and instead of the company issuing new shares, the founder sells 20 of their shares directly to the investor. That's problematic because the investment money goes to the founder, not the company. But investors are investing in the business. We ought to not buying out the founder. The company misses out on the capital it needs to grow. The founder may also trigger a capital gains tax event. For example, if they got those shares at $1 each and now sell them at $2, that $1 profit is taxable. The better approach? Have the company issue new shares directly to the investor, so the funds go into the business, not the founder's pocket, and there's no unnecessary tax consequence. Let's break down the estimated legal costs involved in raising capital, depending on the path you take. If you're using a safe note, you can expect legal fees in the range of $1,000 to $3,000. That typically covers having the safe drafted and negotiated by a lawyer. It's the most streamlined option of the three. For a convertible note, costs are usually a bit higher, ranging from $1,500 to $4,000. That's because convertible notes are more complex. They involve debt terms, interest, maturity dates, and investor options. If you're raising capital by issuing shares, legal fees will depend heavily on the size and complexity of the raise. This process usually includes drafting the term sheet, preparing the subscription agreement, drafting the shareholders agreement, updating the member register, issuing share certificates, and preparing all necessary resolutions for shareholder and director approvals. For a straightforward equity raise, fees might start as low as $4,000, but there's no real upper limit. The more complex the raise, the more work is involved. Here's a rough guide. If you're raising $1 million, legal fees might be around $6,000 to $10,000. For $5 million, legal fees could land around $10,000 to $20,000. For $10 million, legal costs may climb to $40,000 to $80,000, plus GST and so on. Need help raising capital? You're in the right place. If you're preparing for a capital raise, whether it's through a SAFE, a convertible note, or issuing shares, I can help. I've worked with around 100 companies on successful capital raising transactions with deal sizes ranging from $50,000 to $15 million. That doesn't even include the debt facilities I've advised on, which have topped $200 million. At Leo Lawyers, we regularly support startups with everything they need before raising capital. That includes cleaning up your corporate structure, resolving related party transactions, and handling employment and intellectual property matters, all to make sure you're investor ready. Let us help you. Call us on our number in the description box or visit our website, leolawyers.com.au. Thanks for watching.